You're gonna plead to a drunk driver?
Yes, sir.
Oh my gosh. What is your problem? Some clothes on before you come back in here. No, you know something? I'm not gonna accept the deal. So were you on the sidewalk, driving on the sidewalk?
Never was I ever driving on the sidewalk.
All right, I'm not gonna accept the deal.
Your Honor, can we have a breakout room?
I guess I didn't mean what I said.
So you lied to me?
No, that's not what no.
Look, Your Honor, he was just.
Wait a minute.
This arrogant punk walked into court for his DUI case and seriously thought showing up shirtless was a good idea, while his kid was crying in the background. Like, how out of touch can you be? What should have been a quick and easy plea deal instantly turned into a mess when he started backpedaling and pretending he was innocent. Judge Perkins wasn't buying it for even a second. The sheer disrespect for the courtroom, and for his own case, is unreal. Showing up like that is basically begging for a contempt charge. Let me know in the comments whether you think he should have been held in contempt for walking into court shirtless. Now let's jump in and watch how this unfolds.
You're gonna plead to a drunk driver?
Yes, sir.
Oh my gosh. What is your problem? Some clothes on before you come back in here. Get your client together, Mr. Ogletree. Now let's go back on the record with Mr. Green. Mr. Green, you indicated you wanted to take the deal. Any objection for having attorney Edward Taylor stand in for your attorney of record, Mr. Ogletree?
No.
State your name, please.
Shamar Green.
All right, Mr. Green, turn your camera on. Can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, sir.
You can put your hand down. Do you understand that the maximum possible penalty for this offense is 93 days in jail and or $5,000 in fines?
Yes.
You understand you have an absolute right to a trial.
Yes.
Mr. Taylor went over your other advice or rights in the breakout room, did he not?
Yes.
You understood those rights?
Yes.
Any questions about those rights?
No.
You know by taking this deal, you're going to give those rights up?
Yes.
Has anyone offered you anything other than what's been stated in the record?
No.
All right, let me draw your attention back to January 1st, 2024, around 5:52 p.m., city of Detroit, in the area of Kentfield Street, 19015. Did you have an occasion on that day to come in encounter with the Detroit Police Department?
Yes.
Were you operating a motor vehicle?
Yes.
Did you have some alcohol before or prior to the operation of that motor vehicle?
Yes.
So during or prior to the operation of the motor vehicle?
Yes.
What kind of alcohol did you have, sir?
I had just took a shot of, I think it was Bacardi.
And then how much? How much?
I had literally just took a shot with my dad.
So you took one shot of Bacardi.
And yeah, that's it. That was.
I'm not satisfied, Counselor.
Mr. Green, one shot would not have your breathalyzer that high. Did you have anything else to go with
I
that?
had something before I took that shot, some wine. That's about it.
Okay.
Well, what is this? What is this, sir? Did you have? I asked you how much you had to drink.
I had wine before that.
How much wine did you have?
I don't remember.
Will you stipulate to the forensic breath alcohol analytical report of a 0.197?
Yes.
All right, his BAC blood alcohol concentration was a staggering 0.197. For context, that's roughly 10 standard drinks, or more than half a pint of whiskey. And yet here he is, standing in court acting like he had nothing to do with it. That's not just denial, that's straight up delusion. But the wildest part isn't even the lying. It's the fact he showed up to a court hearing practically half naked, like he was just hanging out on his porch. That kind of move is guaranteed to make a judge lose patience fast. I mean, if you're going to court, the bare minimum is wearing a shirt. What really blows my mind is how often defendants try to argue against their own plea deals. You already agreed to it. Why sabotage the one thing keeping you out of jail? That's like climbing into a lifeboat and then punching holes in it. And all it does is make the judge double down on the consequences. Some people really do operate with peanut-sized brains.
Mr.
Yes.
For a .191, you'll stipulate to that on your client's behalf?
So stipulated, Your Honor.
Did this alcohol impair your ability, does alcohol affect your ability to properly operate this vehicle, sir?
No.
Yes. Mr. Green, in order to take this plea, you have to state that you were impaired at the time
Yes.
that you got.
No, you know something, I'm not gonna accept the deal. You're sitting here telling the court that you're at a .197. And it didn't have any effect on you operating this vehicle?
Yes, I'm sorry.
No, you said no.
Your Honor, his driver was confused, Your Honor, because he didn't even remember how much he drank. That's how intoxicated he was, Your Honor.
Unless he's so drunk that he doesn't even know that this is, well, let me see what happened, why he got stopped. So were you on the sidewalk, driving on the sidewalk?
Never was I ever driving on the sidewalk.
All right, I'm not gonna accept the deal.
Your Honor, can we have a breakout room?
It says that he, on the PBT was taken, and this is the investigator's report, and it was, at that time, the PBT registered a .208. You may need some, I'm gonna order a substance abuse evaluation as well. You know, put you in a breakout room and speak with him again. Rejoin the room, we'll pass the matter. First line of the report says they called him driving on the sidewalk. I don't know what that means. I'm gonna get the officer in here to give me some explanation if you want to take the deal. Join the room, please. Mr. Ogletree, when you were out, are you there now?
I'm here, Your Honor.
All right, so here's the deal with your client. He indicates to the court that first and foremost, he started off saying that he only had one shot of Bacardi with his father. And he's got a .19 level of intoxication. So unless that shot was the whole half a pint or more, then that's not believable. Then he changes and in fact, I guess his memory was refreshed for some reason, and he says, I had some wine too, and I don't know how much wine I had. So we go ahead and start on with the plea. In the police report, it says he's driving on the sidewalk. He said absolutely he's not driving on the sidewalk. And then I asked him, did this affect his ability to drive? He said absolutely not. So I think this matter needs to be set back. I'll give you an opportunity to respond to all that and have the officer come in and let's see what that officer, well, the officer in the report is saying a lot different than what he's saying. So what do you have to say about that?
Yeah, I did speak to Sister Counsel earlier when I appeared the first time, and she was saying she wouldn't have objection to a no contest.
Excuse me, for the record, you know what? For the record, Attorney Ogletree, you went and got a deviation from my supervisor. That was not my offer.
No, okay. So I just want to be clear on the record. In terms, I did request deviation, as I told the court the first time, but we did speak, and I asked, would you be okay with a no contest? So I don't know if you're saying you're not okay with a no contest now.
As I informed you, I'd leave that to the discretion of the court. No, if the court wants to take a no contest, I have no problem.
Well, and the thing is that I just feel that Mr. Green is not being totally upfront with the court. That's what I feel he's doing, and not unless he's so intoxicated, which I can believe that at a point 19 that he just really didn't have. But I don't like it when it's time to just you're already making a deal and you've got the deal secured, and now it's time to put on the record what you actually did. And he goes totally off and just says, I only had one shot of Bacardi.
This case is a textbook example of arrogance paired with zero accountability. He was literally caught driving drunk on the sidewalk and still wants to stand there arguing that he's innocent. If he truly believed that, he never would have accepted the plea deal in the first place. The fact that he did tells you everything you need to know. He knew he was guilty, but when it came time to own it, he tried to squirm his way out instead. No accountability at all. And that's exactly why the deal was pulled. Judges don't play games. They want honesty, even when it's ugly, especially if you've already agreed to a plea deal. All this proved is that he's not serious about changing. Whether that's how he was raised or just pure ego, who knows? What I do know is he's about to face a lot more heat than if he'd just taken the deal quietly. And that's the price you pay for refusing to take responsibility in a courtroom.
So what is it, Mr. Green? Do you recall this night?
Yes.
Oh, and did I say I asked him, did this alcohol affect his ability to drive? He said no.
Yeah, he informed me that he misspoke when he said that.
How is that? How'd you misspeak, Mr. Green?
Because I said the wrong thing, I guess. I didn't mean what I said.
So you lied to me?
No, that's not what no.
Look, Your Honor, he was just.
Wait a minute. How did it affect your ability to drive or not? Or
Yes.
did you believe that it didn't affect your ability to drive?
No, that's not what I was saying.
Do you recall the incident?
Yes.
All right, I'm going to find him guilty as to the operating while intoxicated. I want a substance abuse evaluation. I need a phone number again from you. I know they probably already have it. I'm referring it to probation. You're going to submit to a pre-sentence investigation report and a substance abuse evaluation. What's the phone number again, please?
My number?
Yes. I do recognize that he has passed the test as far as this alcohol test, but I still, with the level of intoxication that he has, with his answers here today, I'm gonna order that test just and for his own benefit, for his age and everything. He's a young man, not even 25 years old or just 25 years old. I'm gonna order that. Sentencing date is going to be.
I didn't hear none of that. Your camera went out. It's disconnected, I guess. There we go. It just fixed.
All right, I'm going to order a substance abuse evaluation based on your age, the level of intoxication that night, and just your answers here today, and just for your own benefit. You're a young man. This is a serious offense, and I just want to see what they say as far as that. Let's set sentencing 45 days out. All right, and I'm going to dismiss the other matters with stipulation of probable cause.
We stipulate to probable cause.
All right, Mr. Green, I'm wishing you the best of luck. I'll see you back on July 23rd.
And
You should still maintain your sobriety.
do I continue to drop once a week with the same?
Absolutely. All the other conditions are still in place.
Okay.
And all right, if there's nothing further, sir, best of luck to you. And again, I don't have to tell you about coming in here, laying down with no shirt on. You should be appropriately dressed for court. This is just like you being in the courtroom, even though you get the benefit of sitting at your, in the comforts of your own home, all right?
Yes, sir.
All right, if there's nothing further, have a very good day, and best of luck to you, all right?
Man, this guy was so out of control you'd think he drank chaos instead of whiskey. And maybe this sounds harsh, but I honestly think he should have gotten at least 30 days behind bars just to send a message. Because it's clear he didn't take any of this seriously. Showing up to court shirtless with his kid crying in the background isn't just careless. It's flat out embarrassing. What really gets me is how many other options he had. Uber, Lyft, a friend, literally any sober ride. But instead, he chose to drive drunk and then still tried to argue his way out of it. If you're caught and you're taking a plea deal, the least you can do is own it. Honestly, the system went easier on him than I expected. He got some basic conditions: stay sober, pay a fine. That's pretty minimal. Maybe it's a second chance, but I'm not convinced he'll actually learn from it.